Okay, so hold on a second.
Sure.
I'm coming at this now from, I'm not a lawyer, so
Yeah.
I'm a non-lawyer mediator.
Mhm.
What does it mean for me? What are the implications on me? What do I have to do? What are the various steps and the forms and
Yeah, it's a really good question because even though the court rules have provided certain forms and sort of template documents, they haven't provided for a template report for a mediator. So the short answer is we don't really know exactly what this report is meant to look like, other than the fact that it's to be made on affidavit, which is a sworn document. You know, an affidavit is a sworn statement that you make before a practicing solicitor or commissioner for oaths. So it's quite a serious document, you know. Um, so, and again, you know, when you're looking as a mediator, as what should I be putting in this report, you have to ask yourself the question of, well, what will this report be used for? Okay. And this is where we come to the sting in the tail of the reporting provisions, which is section 21, which deals with the costs of mediation. Okay. And that provides that where a court invitation to mediation, such as that in section 16, has been made, um, and you know the matter has come before the court has to make a decision on costs. When it is doing so, it may, where it considers just, and that's the terminology, have regard to, and I'm quoting this from the Act, A, any unreasonable refusal or failure by a party to the proceedings to consider using mediation, and B, any unreasonable refusal or failure by a party to the proceedings to attend mediation. Okay? So here we have a situation where you could have a sequence of events where a court invites parties using its powers under Section 16 to go to mediation. Okay? Parties say, yes, judge, we'll go to mediation. They hire you as a mediator. One of the parties turns up and the other party doesn't. You now, under Section 17, have to make a report back to the court saying the mediation didn't proceed because party B didn't turn up. Then the judge says, okay, well, I'm going to invoke Section 21 and decide that this is an unreasonable refusal by a party to attend mediation, and I'm going to penalise them for costs. So that makes that mediator's report quite a significant step in the process to a costs decision. And it's one thing if, you know, if there's a very clear cut thing that's being reported on is that, you know, the party confirmed he'd be there but didn't turn up. But if it's a little bit more nebulous than that, I suppose an example would be, you know, if a mediator, say, put in a report, well, the party turned up but didn't make any real effort to engage or didn't say anything for the duration of the mediation. If that goes in a report, a judge uses that as a basis to penalise the person for costs. That could put the mediator in a very vulnerable position on the basis of their report. So, you know, this has a lot of implications for mediators. On the one hand, obviously, you need to be careful what you're putting in your report, but it also has implications for lawyers and for the parties going to mediation.